such as one witness's immediate impression of what Dugan was doing in the hallway. It demonstrates that Dugan did nothing to even ensure the prosecutor was notified or even made aware of what happened in the illegal aliens case, which is just sick as a judge. I mean, it's like, are all talking garbage about ICE? Do you think that their bias maybe manifests itself in their work product? They should all be fired, honestly. Judge Dugan, the backdoor judge, has trial coming up very soon. We have this audio recording that we're fighting over. She does not want it to come into court at all, has filed a motion to preclude it, and the DOJ, the prosecution, have responded. They said, okay, some of that audio recording from inside the courtroom when she let an illegal alien use her back door after ICE was there to try to arrest him, some of that the government says we don't really care about. We don't need to have that audio come in, but there is a key bit that we do want in, and they articulate what exactly that is in this filing. In response to Judge Dugan's, the backdoor judge, this is the DOJ's response to her motion to exclude the courtroom audio from the trial starting soon. The United States government, the DOJ, courtesy of Pam Bondi and the prosecutors, they say the United States of America, by our lawyers, respond to Doogie's motion in limine to exclude portions of the courtroom audio when she was not in the courtroom. Okay, so she's the judge, she's in and out, leaves to go distract the ICE agents, comes back into the courtroom. People are blabbering the entire time. It's recording everything. It's all on audio. Now, the United States does not oppose most of Doogie's requests. However, the United States requests that the court allow the admission of the slightly more than 3 minutes of audio that captures activity after the court was called into session, but when she had stepped out of the courtroom. Okay, so recordings are happening. She's not in. She comes in, starts the proceedings. Then she leaves, goes, distracts the ICE agents, obstructs them, comes back in. When she's gone, it's about 3 minutes. We definitely want that. The United States agrees with Doogie as to the nearly 30 minutes of the 33-minute audio recording. They don't care about the 30. We don't need that. It does not oppose her request to exclude the 17 minutes that occurred prior to when the court was called into session. All rise. Court presiding. She comes out. We want that audio once that starts. The U.S. also agrees that all the audio when she is in the courtroom after the court is called into session is admissible. So anything that she heard or saw, we definitely want that. The only points of disagreement with her between the prosecution and the defense is 2 minutes and 45 seconds of audio that captured activity after Doogie left the courtroom following court being called into session that morning. She's in, she leaves. And 2, the approximate 30 seconds of audio that captured discussions that occurred when she was near and exited briefly through a jury door with EFR, the illegal beater, and his attorney. Okay, so the illegal alien who beat somebody, that's why he was in court, the victims were in court, but she let him use her back jury door. And there's 30 seconds of audio that captures that. Now we'll learn more about it. Now, evidence is relevant and can come in if it has any tendency to make a fact of consequence more or less probable than without that evidence. So if we need to decide on something, will this fact help us decide that thing? Yes or no? A fact of consequence is not limited to the ultimate issue or elements in the case. Rather, a fact of consequence can be any step along the path of inference that leads to an ultimate fact. Well, it doesn't help us answer this exactly, but it helps us answer this, and this helps us answer that. So it does not matter under Rule 401 that there are multiple evidentiary routes to the ultimate fact other than the one relied on by the proponent of the evidence. Now, to be relevant, evidence need not conclusively decide the ultimate issue. It's not like this will prove her guilt. All it needs to do is to help our proposition that she was obstructing in this proceeding more probable, but it must advance the inquiry in some way, shape, or form. Okay, those are the rules. So does this evidence advance the claim? And of course, relevant evidence may also be excluded under Rule 403. So 401, is this helpful? Is this going to be useful in our prosecution? And if so, yes, great. It's relevant, but is it prejudicial? Rule 403 is the balancing test. If it's more helpful than it is harmful, it comes in. If it's more harmful than it is helpful, it stays out. Rule 403, big rule, talk about it all the time. Relevant evidence may be excluded only if, so it's relevant under 401, but we still want to keep it out, only if its probative value, how it would help us, is substantially outweighed by unfair prejudice, the harm. It's going to be unfair to Doogie. It's going to mislead the jury. They're going to be confused. What does this evidence mean? I don't know. Is it going to cause a delay? No. Is it going to waste time in the trial? No. Is it going to present cumulative evidence? Is it going to be duplicative? We've already heard that. Don't need to hear it again. They say no. The approximately 2 minutes and 45 seconds of audio that captured events in the courtroom after Doogie left shortly following the court being called into session is relevant in at least a few reasons. For instance, it will demonstrate that the illegal alien and his attorney were not at the counsel table during the time. It was was not the time for their case to be called. They were not at the table. The prosecution was not over there. They weren't calling their case. The illegal alien and their attorneys were maybe behind the bar, maybe sitting in the pews. In fact, another criminal defense attorney called WP and his client were instead at the table. Now, based on their conversation with the defendant, Dugan, after she had taken the bench, this defense attorney clearly expected his client's case to be called first. So the microphone at the counsel table largely captures WP's conversation, not EFR's conversation or that of his attorney. Okay, so the illegal and their attorney not at the table. Both WP and EFR's criminal defense attorney are expected to testify at trial. So the other defense attorney was in the room and the illegal's lawyer are going to be at trial. The audio will corroborate both of their recollections and their expectations at the time my case was going to be called. Now, in addition, WP, the other defense attorney, was aware that his conversation was being recorded and he told his client, don't speak about the case. Like as we talked, shut up, write it down and pass it over on a notepad. Don't speak until we're outside the courtroom. Relatedly, that portion of the audio provides helpful context for what immediately precedes the highly relevant audio of what Dugan did when she came back into the court. Now, if you listen to the entirety of the audio, it captures the sudden, unexpected change that occurs when Doogie, the judge, re-enters and she tells the defense attorney who's seated at the table ready to call his case to step aside. All right, WP, we're not going to be calling your case. She enters the court. It's not your turn. Move. And it's clear by listening to the audio immediately preceding her return to the courtroom that her directive was an unexpected change. Okay, they go, what? Ready. The case is right here. It also captures other relevant evidence, and they have a footnote. It says the defendant, Dugan, has filed the transcript under seal, but the actual audio, which captures tone of voice, makes the surprise even more clear. Okay, tone of voice. WP, in the transcript, he says, okay, Your Honor. In the transcript, yes, Your Honor. That sounds reasonable. I'll move over. But he goes, Your Honor? Yes, Your Honor? You want me to move? It sounds different. And you go, okay. Prosecution's like, all right, okay. Of what he was doing, such as one witness's immediate impression of what Dugan was doing in the hallway. So what the defendant was doing in the hallway was obstructing and distracting the ICE people. So some other random witness said, I think the judge is outside talking to the ICE people for whatever. Like, what's she doing out there? And why the defendant's clerk, Dugan's clerk, took certain actions before Dugan returned. And the clerk, as we know, just continued the case. The audio will play a conversation in which the court clerk told a state public defender that the defendant, Dugan, was calling the chief judge. So some public defender who may have been representing an illegal or some other illegal or some other person says, where's the judge at? Oh, she's calling the chief judge, the clerk said. Now, the state's public defender, who was just in the public hallway, corrected the clerk by sharing his impression of what he just observed. So this other witness, the public defender, he says, well, she's out there confronting them in the audio. The clerk eventually responds, good, glad they are obstructing. Co-conspirator, arrest them, which explains why the clerk went into the public hallway to observe for himself. He's like, yeah, Dugan, she's such a hero. I can't wait to go see this. Goes out, and then ultimately why the defendant needed to wave for the clerk to accompany her back into the courtroom through the entrance from the public hallway after she confronted members of the arrest team. Okay, and clerks are usually very, supportive of their judges, unless the judges are maniacs, but they're on the same team, like politically aligned. Oh, she's calling the chief judge. Well, actually, she's not calling them at all. She's out front. She's confronting them. Clerk says, good. Let me go take a look. Clerk walks out just to go get a little taste of her heroism. Now, Dugan does not explain how any of that evidence is unfairly prejudicial. It gives us great context. Why that would confuse any issues, why that would be a waste of time, or why that would be needlessly cumulative. Less than 3 minutes of audio is not a significant amount of time. Nothing critical is said about her, and rather than confuse any issues, it actually provides helpful context for the extremely relevant activity that follows it. And while there will be some testimony about what occurs during those less than 3 minutes in the courtroom, playing the audio is not needlessly cumulative. Like, yeah, we're going to have these people come in and talk about it, but we want them to hear it in real time. Look what happened. The United States, because of its heavy burden, is entitled to cumulative evidence in that little way. Now, similarly, the additional 30 seconds of audio that captures activity in the courtroom immediately after scheduling EFR's matter off record is also relevant. So as I explained, you go to the table, you call your case. Everything's open in public on the record. If you want to submit something, not in that public forum, then you would submit it as a motion just straight to the court and you wouldn't address it all in public. But they're there for that reason. And EFR, the illegal alien who's now been deported, he was charged with beating people, victims. It wasn't like just, got caught with possession of drugs. People call it victimless crime. Okay. He was beating people. The victims were in the courtroom. They knew that he had a scheduled court proceeding. That's why they showed up, so that they could make their position heard and even just show up in court to be seen. They have rights too. So what she did is continued it off the record. At the other attorney, she said, go over here. We're not doing your case yet. For instance, it captures the state prosecutor talking with another defense attorney, which demonstrates a relevant point. It demonstrates that Dugan did nothing to even ensure the prosecutor was notified or even made aware of what happened in the illegal aliens case, which is just sick as a judge. She's got victims in the courtroom who got beat by this dude. She just continues it, postpones it another 30 days, and she allowed him to appear telephonically at future proceedings so that he could not be deported. The fact, moreover, that fact will provide a relevant contrast for the jury. When they hear the remaining portion of the audio, it captures how Dugan addressed other cases in her courtroom that morning. For instance, the audio will demonstrate that Dugan, less than 10 minutes later, told a defense attorney to make sure the prosecutor, who was not participating in the discussion, was aware of dates scheduled off the record so she could make any necessary notifications to any alleged victims. The victims were in the courtroom. You could have notified them right there. The defendant did not do that when EFR's matter was being scheduled off the record, right? So other victims were in the courtroom and the judge dealt with them differently. This contrast will be relevant. It will tend to show that the way that Dugan handled EFR's matter was hardly routine at all, an issue which the court already ruled is relevant and may be explored at trial. She said, I do this all the time. Well, you didn't do it all the time that day. In fact, other victims that were there, you talked to prosecutors about dates and making sure that they're apprised of everything. Here, you continue the case without apprising the prosecutor or the victims of anything. We can explore that at trial. In fact, in a prior ruling, the government was told they can introduce evidence about whether the judge handled the case in a customary fashion. She didn't. The audio shows that. Now, also, the court will give the government, quote, some leeway at trial to demonstrate that they were handled here in an unusual fashion, which it was. Now, this 30-second portion also captures the conversation between Dugan's clerk and the court reporter. They're both talking about ICE, and the clerk shared with the court reporter the derogatory term he claimed to have said to one of the federal agents in the public hallway. Okay, so the court clerk goes out and starts, lobbing profanities at these ICE agents. Their conversation about ICE tends to show that they, at least, had the immediate impression that the judge's unusual way of handling this case was related to the ICE presence in the hallway. So the court clerk and the court reporter, are all talking garbage about ICE. Do you think that their bias maybe manifests itself in their work product? They should all be fired, honestly. They don't respect the enforcement of the law. They're working in courts. Their values are misaligned. None of the concerns listed in Rule 403 outweigh this portion of the audio's value. It's probative. It's not harmful, let alone substantially harmful. During this 30-second portion, nothing is said critical of Dugan. There is nothing cumulative about it, and it confuses no issues at all. So the United States, though, does agree with Dugan that the court should exclude the 17 minutes preceding the initial entrance into the courtroom. Everything the audio captured after court was called into session, though, is relevant, and none of its probative value, even when Dugan is briefly away out of the court, is substantially outweighed by unfair prejudice. It's not a waste of time. It's not a confusion of the issues. It's not cumulative. So the United States requests that you grant some of it, because we don't need all of it, but deny the rest of it. We want this evidence coming into court, sent in this 4th day of December, 2025. So Judge Dugan and her trial will be coming up soon, and they're already going into jury selection. Of course, I think this will be a fun one to follow if you're interested in it, of course. But we see final order coming down from the judge saying, at the final pretrial, the parties were instructed to confer and provide a list of prospective jurors from the supplemental batch of 50 that should be struck or excused for cause. They're already selecting. The parties have provided under seal a list of 10 jurors they agree should be excused based on what we know already, as well as a list of 10 others over which they disagree. Consistent with my previous ruling, I will strike the 10 agreed upon jurors and take no action on the others until voir dire is conducted. As also discussed at the final, any remaining prospective jurors from the batch will be on call for Friday, December 12th, 2025. Trial starting very soon, coming in next week. So we'll be here to cover this one, my friends, but it sounds like, they're making a very good argument as to why that audio should come in. I don't think it is problematic or prejudicial in any of the ways that Doogie says it is, but no decision yet. We'll keep our eye on this one and hope that you join us as we do.